In today's lecture, we're going to talk about the legal liability or the liability environment that auditors work in. To understand this, we need to look at it from the perspective of engagement risk. An auditor's exposure to financial loss and damage to reputation defines this concept of engagement risk. The effects of a lawsuit on an audit firm can be tremendous. Litigation cases are expensive for the audit firm. They result in monetary loss. They may consume time of audit firm members and hurt their reputation. So even if we win the case, it's very possible that the effect on the organization is going to be detrimental. You notice this, the practice protection costs are the second highest cost for the audit firm after employee compensation expenses. The reasons for litigation against the audit firm, there's a couple of concepts that we need to understand. Legal liability doctrine permits a recovery of the full amount of settlement from an external audit firm, even though that firm is found to be only partially responsible. There's three concepts that we're going to talk about, and these are the three concepts that you need to understand and remember. The deep pocket theory. We're suing another party based upon the perceived ability of that party to pay damages. Keep in mind, consider the audit that we do of a firm where the firm goes bankrupt. Well, guess what? That firm no longer has the ability to pay for damages, but we do. So the fact that we are a part of that opens us up for litigation. Joint and several liability, this apportions the loss among all defendants, and you notice how we qualify all defendants who have the ability to pay for damages regardless of the level of fault. This is designed to protect users suffering losses because of misplaced reliance on materially misstated financial statement. And then finally, the third doctrine is proportional liability, payment by an individual defendant based upon the degree of fault. We need to understand where liability comes from. Now you notice the last point is statutory law. Statutory law is developed through legislation. This includes the Securities Act of 1933 and 1934, Sarbanes-Oxley, as well as a couple of other items that we'll talk about, but we're going to move those to another discussion. We're going to focus on common law and contract law. Common law is the liability where there is a breach of contract. The contract is between the external auditor and the client for the performance of the financial statement audit. Common law is driven by court decisions. These are usually state-specific court decisions. So one of the things that you'll see in the CPA exam is when they talk about common law, and we're going to talk about a couple of these in this discussion, is they will specify this as being state-specific. So in common law, we look at these concepts of neglect, gross neglect, or fraud. Breach of contract is simply a failure to perform a contract that has not been executed. For example, for the audit firm, it's possible that the contract relates to clients and designated third-party beneficiaries. But you notice the key word is designated third-party beneficiaries. Legal action is caused by neglect. Neglect is simply a failure to exercise reasonable care. Gross neglect is a failure to use the minimal care of evidence of activities that show a recklessness or careless disregard for truth. And then ultimately we're talking about fraud. Now you notice this last point here is scienter. This is knowledge on the part of a person making representations at the time they are made that they are false. Who can sue the auditor? Is it the client? Well, the client, generally speaking, always can sue the auditor. Under statutory law, third parties can sue the auditor. Under common law, it depends upon the common law statutes. So, or the common law, the court cases that are used as the basis for decisions. So again, back to the case of what we're looking at is we're looking at state-specific laws and how they apply in specific circumstances. Common law liability to client breach of contract can be held liable to clients under common law and or under common law for breach of contract. Can be sued under concept of neglect, gross neglect, and fraud. Causes for action: violating client confidentiality, failure to provide audit reports on time, failure to disclose a material error, or withdrawing from an audit engagement without justification. Remedies for the contract is to specific performance. So if we haven't completed the audit, specific performance will be to complete the audit. There's a grant and injunction prohibiting the auditor from certain acts, provide for recovery of the lost amounts. Now, an auditor's argument related to common law liability is that he or she exercised due professional care. Keep in mind that in our audit report, we state that we provide reasonable assurances. We're not providing absolute assurance. The other piece is that the client was contributory in regards to the neglect. He or she or the client was not providing the appropriate information, or the client's losses were not caused by the breach of contract. To win a claim against the auditor, third parties suing must prove they suffered a loss, the loss was due to reliance on misleading financial statements, and the auditor knew or should have known that the financial statements were misleading. Foreseeability and negligence. The critical point in determining the claim is the likelihood that the auditor could foresee the user relying on audited financial statement information. The less foreseeable plaintiffs need to establish gross neglect. Foreseeable users in some jurisdictions have to establish only a negligent claim. Now, one of the things that we need to understand is that common law is driven by legal cases. So the cases that we need to understand are these four cases here: the Ultramarines versus Touche, the Credit Alliance, Rush Factors, and Rosenblum. So you notice how this moves from the narrowest definition of eligible third parties finally to the broadest definition of third parties. Again, back to what you need to understand related to common law, it's how these four cases are impacting the third party neglect. This is actually a very good table, and I want to go through this over the next couple of minutes. So you notice that common law was developed over time by judges issuing legal opinions as cases are decided. The legal principles announced in a case typically become precedent for other judges in the same jurisdiction. So again, you notice that this is state specific to consider when deciding similar cases in the future. In order to prevail in ordinary neglect, the third party must prove all of the following. The auditor had a duty to the plaintiff. The auditor breached that duty. The breach of duty was the direct result of the third party's loss, and the third party suffered an actual loss. So you notice here in privity, and again we're talking about privity, this is the Ultramarines case, auditors can be held liable to third parties with privity with which there is a contract or specific agreement. We go to the next level, which is Credit Alliance. In Credit Alliance, this is near privity. The third party is known and there has been some direct communication. For example, the auditor provides the audit report directly to the third party. Foreseeable, restatement standard, this is the rush factor. The auditor's liability is expanded to include all third parties whose reliance is actually foreseen, even if this person is unknown to the auditor. And then ultimately, the reasonably foreseeable, this is the Rosenblum case, is the auditor's liability includes all reasonably foreseeable parties who relied on the financial statements. Note, in any jurisdiction, regardless of third-party determination with respects to the auditor, a third party can always successfully bring suit against the auditor if fraud or gross neglect can be proved. The auditor's response is no duty is owed, the client was negligent, the audit was performed in accordance with generally accepted auditing standards, the client suffered no loss, any loss was caused by other events, and the claim was invalid because the statute of limitations has expired. So you notice the complexities related to this, but the takeaway from our discussion is that what we're talking about is common law. Common law is driven by the jurisdictions issuing decisions, legal opinions. In court cases, these legal opinions provide the precedent. We have the four cases, the ultramarines, which is privity. We finally go to the Rosenblum, which is the reasonably foreseeable. In our next discussion, we're going to talk about statutes, but this concludes our discussion related to common law and contract liability.